Our topic today is keeping children safe online. The session will be recorded and we will put it on our website. So if anybody wants to have another listen, they'll find it on the website. A couple of housekeeping points. Could I ask that everyone keeps their mics muted so that we can minimize feedback problems? As regards questions, if anyone has any questions as we're going through the topic, please post those in the chat, and after the webinar we'll put together answers, or hopefully answers, to all those questions, which we'll send to everybody who joined the webinar. There are three of us speaking today. Those are mugshots of us all. So it's myself, Charlotte, and Zoe. I'm going to be doing an introduction to the Children's Code. If you could do the next slide, please. I'll do an introduction to the Children's Code and who it applies to. Charlotte will then take us through the Children's Code standards in a bit more detail. And then Zoe will talk about legislative requirements and developments, and talk about some practical steps that you can take to help in this area. So, what is the Children's Code? Well, the Children's Code introduces the concept of age-appropriate design, which is all about ensuring that online services are suitable for children and protect children and give them the information that they need. Remembering, of course, that children have exactly the same rights in terms of data protection and the protection of that data as adults. So who does the code apply to? Well, first, it applies to information society services which are likely to be accessed by children. So that doesn't mean services intended for children, but any information services that are likely to be accessed by children. There are some obvious examples of services aimed primarily at adults, which children are going to be interested in, such as streaming services for music or online TV. And those are likely to be accessed by children, so those are covered. Information society services are any service normally provided for remuneration at a distance by electronic means and at the individual request of a recipient of services. So that's actually a very broad definition, and it includes things such as obviously websites and apps, but also social media, streaming services, as I've just mentioned, online games, web-connected toys, anything that essentially falls into that definition of a service normally provided for remuneration at a distance by electronic means. Next slide, please. The code applies to UK companies and non-UK companies who process the personal data of UK children. So anyone who falls into that definition must comply with the code. I'll now pass on to Charlotte, who will take us through the 15 standards that the code establishes and in more detail.
Thanks, Tom. So the Children's Code doesn't deviate from the data protection framework and the general principles that are captured by the UK GDPR, but they do recognise that children may be less aware of the risks and consequences about their rights and personal information, which is why there's a specific set of standards that apply to processing children's data. There's a lot of information to cover here, so we're providing a fairly high-level overview of the standards along with some practical considerations. So the first standard, which you'll see underpins the remaining standards, is acting in the best interests of the child. This should be the primary consideration when designing and developing your online services if they are likely to be accessed by children. Going back to Tom's point around it being pinned on likely to be accessed by children, not necessarily targeted at children. This means supporting the child's needs for physical and emotional safety, their development, their privacy, and generally their overall well-being. So basically, whatever is best for that individual child should be paramount. Standard 2 is undertaking data protection impact assessments. So you'll hopefully be familiar with this already, as it's a key principle and a key step to take when assessing your data protection processing. What this looks to do is mitigate the risks to the rights and freedoms of children who are likely to access your services, which arise from your data processing activities. And you should be taking into account different ages, capacities, and the development needs to ensure that your impact assessment builds in compliance with the code and again has the children's interests at the heart of it. Age appropriate application is standard 3. You must be taking a risk-based approach to recognizing the age of individual users and ensure that you effectively apply the standards in the code to those child users. So you can either establish the age with a level of certainty if you have a method for doing that, which are appropriate to the risks of associated with your online services, or you can apply the standards in the code to your users across the board if you aren't able to identify the age or you are doing services that are specifically targeted at children. If you are looking to adopt practices that are age specific, the ICO provides some helpful guidance on the capacity that's expected of different age ranges, including the different skills and behaviours that are typical for children at the different stages of their development. And they break these down into 5 different categories. The first being 0 to 5, that's your pre and early literacy stage. Category 2 is 6 to 9-year-olds being the core primary school age. Then we have 10 to 12, which is the transition years. 13 to 15 are early teens, and 16 to 17, which are young people approaching adulthood. And obviously there's a recognition there that you might not be treating them that differently in terms of the information you're provided that you would provide to somebody over the age of 18. Standard 4 is dealing with transparency. Again, this is one of the key principles that underpins the entire data protection regime, so I'd expect that you're already familiar with this. But the privacy information you provide to users and other published terms, policies, your internal standards, they must be concise, prominent, and in a clear language and suited to the age of the child that you are providing your services to. You should be providing additional specific sort of bite-sized explanations about how you use their personal data at the point that their use is activated in a similar way that you would for adults when you're processing their personal data. As a practical step, we would suggest that you have both a children's and an adult's privacy notice if you're dealing with both, but you may consider having child-facing sections of your overarching privacy notice, depending on the nature of your services. But again, anything that's targeted at children should be tailored to their specific age and understanding. And standard 5 is detrimental use of data. So you shouldn't use children's personal information in any way that would be shown to detriment their health at all. That could be physical or mental or their overall well-being. You should also take into account here any industry codes of practice or other regulatory provisions or government advice in these areas. There are some very useful sector-specific advice and codes that you can find available online that will help you manage this and help you identify use cases that may be detrimental to children when using online services. And moving on to standard number 6, which is policies and community standards. You should implement an accountability program within your organization to effectively address the standards, which is tailored to the size and the resources of your company. So again, you need to be taking into account the risks to children posed by the services that you're providing, and these should be specific and risk-based. You should also be ensuring that you're upholding any policies and standards that you have in place, including things like privacy notices, age restrictions, behaviour rules, content policies, etc. Make sure that your employees are aware what they should or shouldn't be doing and how you deal with children's data internally as an organisation. Standard number 7 is default settings, and this is one that we're seeing an increasing amount of media around, particularly with some of the bigger players like Facebook, Instagram, etc. But settings must be set at high privacy by default when you are processing children's data and dealing with children's online services. The only reason that you might choose or may be able to not use high privacy by default is if you can demonstrate a compelling reason to have a different default setting. But again, this is underpinned and must take into account the best interests of the child. Standard 8 is data minimization. Again, probably a principle you're already aware of from the GDPR. It's one of the key principles that underpins the data protection framework. But you should only collect and retain a minimum amount of personal data that you need to provide the elements of your service in which a child is actively and knowingly engaging. You should be giving children separate choices over which elements they wish to activate, and you shouldn't be collecting additional personal information about children for the sake of it. Standard 9 is data sharing, so don't disclose children's data to other organisations or individuals unless you can demonstrate a compelling reason to do so, again, taking into account the best interests of that child. You need to be thinking about the overarching principles here as well. So what is your legal basis for sharing that data? If you cannot establish that, then you shouldn't be sharing it. And it does need to have a level of thought and risk assessment around what is the purpose of that data sharing. Standard 10 is geolocations. So switch geolocation options off by default, again, unless you can demonstrate a compelling reason otherwise. And again, taking into account the best interests of the child. You should provide an obvious sign for children when location tracking is turned on and is active, and options which make a child's location visible to others must be turned off at the end of their session. This is particularly relevant for things like gaming. Standard 11 links to parent controls. So if you do provide parent controls, give the child age appropriate information about this. If your online services allows a parent or carer to monitor their child's online activity or track their location or behaviors, you should be providing signposting to the child about when they are being monitored. It's also an important point here to note that the GDPR provides that if you're relying on consent as your lawful basis for collecting and processing personal data about children, a child must be at least 13 to be able to give their own consent. If they're under 13, the processing would only be lawful if the consent was given by somebody with parental responsibility. And that comes back to this point around parental controls. What is the context in which you're processing that children's data? What is the age of that individual? And think carefully around the context in which you are collecting children's consent and processing their information. Standard 12 is profiling. So this is where an organization builds a profile about you based on your online usage and behaviors. You should be switching options which use profiling off by default when dealing with children and children's personal data, and only allow profiling if you have appropriate measures in place to protect the child from harmful effects. So this could be the child being fed content that's detrimental to their health or well-being, and that could be based on information that they've tried to access online previously. So I'm sure you're all well aware of targeted advertising, and I have no doubt, experienced it as an adult. If you look at something online, you will then be targeted by companies selling a similar product or service. And as a service provider for children's online services, you need to be taking this into account and making sure that you're protecting children from being subject to this targeted advertising if it could be detrimental to them. Nudge techniques is another interesting one. This is a feature which leads or encourages the user to follow a particular path, normally set out by the designer or the organization behind the website. And as part of that decision-making process, they're prompted to follow a particular route. So an example would be if you're asked if you'd like to sign up to a website or to a mailing list, and whether you'd like to proceed, and the yes option is a lot more prominent. It might be in capitals, it might be a big green button, and often there's a no thanks, very small underneath. That would be considered a nudge technique, but there are lots out there. So you need to be careful not to use these nudge techniques or lead or encourage children to provide unnecessary personal data, or in any way weaken their privacy protections by doing this. Standard 14 is connected toys and devices. So these are children's toys and devices which are connected to the internet. They're physical products, but they're supported by functionality provided through an internet connection. So an example might be a toy with a microphone that records what the child's saying and then sends this data back to your servers as an organization so that you can then personalize what that toy says, the responses. Another example is something like children's fitness trackers, which are now readily available, which is taking and recording information about that child's activity and then transmitting it back to the organisation, and you might have access to a report or something of that nature. If you are providing these types of connected toys and devices, you need to conform to the standards in the code. If the device which collects the personal data and transmits it via a network back to you in this way, because you are then processing that information. If you provide electronic toys or devices that don't connect to the internet and they're only storing the data within the device itself, then the code doesn't apply in that circumstance because you aren't processing that additional personal information. And the final code, final standard in the children's code is online tools. So you should provide prominent and accessible tools to help children exercise their data protection rights and report any concerns. Again, this should be age appropriate and easy to use. This might be things like using icons or audio prompts instead of words and texts, again, taking into account the different reading abilities and skill set that that child and that age range might have. So one of the key drivers for implementing the children's code and reviewing how children's data is processed is the use of and the influence of social media platforms by children. And it's now a fundamental part of the day-to-day lives of young people. So it's really important that the data protection regime affords them the right level of privacy and protection that they need in this space. It's good to see that other jurisdictions have followed suit behind the UK. So things like the Californian Age Appropriate Design Code Bill uses the ICO's Children's Code as a template, and UNICEF are currently looking into how these protections can be implemented globally. So it is a really topical area and one that I think we're going to see a lot more information about in sort of the foreseeable. There is still some way to go, but there's been a lot of positive changes, particularly in the last 18 months. We've seen the likes of Facebook, Instagram, Google, YouTube take some really positive steps to increase children's safety online. And Zoe is going to talk about that in more detail.
Thank you, Charlotte. So protecting children online, why is this something that your company should be taking seriously? Now, there's no doubt that the internet is a wonderful thing. It's brought us here today, but it certainly was not designed with children in line. And you might have seen from media attention around some big players such as TikTok, Facebook and Instagram, that this is an area that the regulator is getting a lot more confident in cracking down on. And we're seeing a real increase in fines and investigation, which in turn lead to an obvious risk of damage to brand and reputation. However, in addition to the obvious moral and at times specific safeguarding duties, there are two main statutory provisions which I want to talk to you about today. These are the Health and Safety at Work Act 1974 and the Online Safety Bill. Slide, please. So the Health and Safety at Work Act 1974, you may be familiar with this. This is certainly my bread and butter. But what you might be more familiar with is Section 2, which places a duty on employers to protect their employees. Now, today I want to talk to you about Section 3. This instead places a general duty on organisations to do what is reasonably practicable to ensure the safety, health and welfare of non-employees who are affected by the conduct of their business. So if a member of public will be affected by your service, including a child who may be using your service, for example, if they're playing a game on your website, they're using an instant chat messenger provided by you, or perhaps they're subject to online advertising from you, then you need to be doing what you can as far as reasonably practicable to make sure they are safe. Now, there's also a duty under the Management of Health and Safety at Work Regulations 1999 to carry out risk assessments, and that's something I'm going to talk about a little more detail later on. So in addition to having commercial and moral reasons, you do actually have a legislative duty. So slide, please. Couple that with the soon-to-be Online Safety Bill. Now, it's important to note firstly, this is not law yet, but it is anticipated to become law in the next year. And when it does, it is really important to be aware of it. So the bill will impose legal requirements on providers of internet services which allow users to encounter content generated, uploaded or shared by other users, providers of search engines which enable users to search multiple websites and databases, and providers of internet services which publish or display pornographic content. So providers will be within the scope of services which are likely to be accessed by children. Therefore, it covers not only services which are targeted at children, but those which are going to be accessed by them. So you can see that the scope is really wide. Platforms which fail to protect people will need to answer to the regulator, who is Ofcom, and they could face fines of 10% of their revenue, or in the most serious of cases, being blocked. So I've just listed on the screen here some of the requirements that the bill will impose. These go from removing illegal content quickly or prevent it from appearing in the first place, right down to providing parents and children with clear and accessible ways to report problems online. So go away, get ahead of the game and familiarise yourself with what the requirements will be so that when the bill does come into play, you're ready for it and you don't find yourself in breach. Slide, please. So what does this mean in practice? We've had a really quick whistle-stop tour as to why you need to be protecting children online. So how do you go about and do this? So slide, please. So risk assessments. If you go away with one thing from today, go away with this. Any risk management system has to start with a risk assessment, and you cannot create an effective risk management system without a good risk assessment. So identify the hazards, assess the risks, control the risks, record your findings and review them. Don't do a risk assessment, put it in a drawer and forget about it. If you change the way you market something, if you introduce a new platform, you will need to review your risk assessment too. Not only will they prevent health and safety incidents occurring in the first place, but they'll provide you with protection if you do. So if, for example, the regulator comes to you and shows that a child hasn't been kept safe online, but you're able to produce a risk assessment to show that you did all that is reasonably practicable, you'll stand in a lot better stead to have a good defence. So work out where your hazards are. Are you putting advertisements on your website? Are children able to use instant messenger through your service? And do you have the necessary controls in place? So next on the list, I've got age limits and age checking, and this is all over the news. It's something that the regulator is really cracking down on. So think about practical ways that you can verify ages. Children are very smart. Think about how they can get around the verification and how you can prevent this. And that kind of leads me on to this next one, which is take the child's view into consideration. In particular, UNICEF recommends that companies seek to take account of views of children by consulting experts. In my view, the expert of a child is going to be a child. So it's really good practice to invite the views of the child themselves when you're designing your processing, including diverse groups who can provide a really good range of feedback. This will help you identify your risks, design safeguards and assess understanding, as well as give you an opportunity to assess your product on the end user. Take a break tools, again, something which is all over the media. We've got Instagram and TikTok doing this. This can be ensuring that if somebody, for example, takes a break in the game, that it doesn't have a detrimental impact on their progress. It could be having an alert if somebody has been on it for too long a length of time, or even just if they've been on your website over a certain hour of the day. Now, these final two things are guidance, one being from the Department for Digital Culture, Media and Sport, and the other keeping children safe in education. So starting with the first one from the Department for Digital Culture, Media and Sport. So they've published a collection of guidance to help businesses protect children on their online platforms. Now, it's important that this isn't specifically tied to any legislative obligations, but it does provide a really good high-level guidance around data protection, age-appropriate content, and protecting children from child sexual exploitation and abuse and counter-terrorism content. It's free, it's there to use. Go away, familiarise yourself and use it. Similarly, keeping children in safe education. Now, this is actually statutory guidance for schools and colleges, which I appreciate the majority are not. However, again, it's just a really useful tool to have for guidance. And in particular, it states that online safety can be categorised into 4 areas of risk, being content, actually being exposed to illegal, inappropriate or harmful content, contact, being subject to harmful online interaction with others, and I'm not just talking about the really serious cases of grooming, even online bullying should come under this. Conduct, personal online behaviour that increases the likelihood of or causes harm, for example, making, sending or receiving explicit images, and commerce, risks such as online gambling, phishing or financial scams. I have no doubt that there are probably 4-year-olds out there with email addresses who may log on to your provision service, and therefore just make sure that what content is going out to those addresses is safe. And it might be really appropriate for you when you do your risk assessment to categorise it into these 4 sections. So go away, familiarise yourself with the guidance and use them to do risk assessments to identify your hazards and control your risks. Slide, please. So I just wanted to finish on the inquiry of Molly Russell, who you may have heard about. There's a reason that online safety is becoming more tightly regulated, and that's because the regulators are realising how serious it is, and the effect that the internet can have on mental health is taken a lot more seriously. So Molly was sadly 14 years old when she took her life. She was suffering from depression and subscribed to a number of social media platforms. Unfortunately, it was access to unsafe content which the coroner said led to her death. Now, the reason why this was so groundbreaking was the first time that a coroner had ruled that an individual had died from the negative effects of online content. He found a causation between Molly going online and her committing suicide. This was huge. Inquests are by their very nature inquisitorial. They're fact finders. They're not there to place blame. However, they can be a really, really powerful indicator of where liability might lie, and evidence which is heard along the way can effectively establish whether duties of care have been met. What the inquest did was highlighted the need for social media platforms to do more to manage the risk of harmful content being posted on their platforms and prevent children and young people from accessing such content. Therefore, it makes online operators just as accountable as other service providers that fall within the scope of the Health and Safety at Work Act, as companies have a duty to secure the health, safety and welfare of people it provides its services to online. Slide, please. So the coroner, when he came to his conclusion, recommended consideration should be taken to regulatory bodies to monitor online platform content. And he identified the following points of the government and social media firms to consider, which I've listed here, things we've talked about: age verification, content not being controlled, no separation between adult and child parts of the platform. There is no doubt that following the Molly Russell inquest and the increased attention on social media companies, that there's going to be a greater pressure to ensure that online service providers are held more accountable, particularly when we have the introduction of the online safety bill. Sorry, my light here requires a bit of waving every now and then. So go away, do your risk assessments, find out where your hazards are and control them. We've got a fantastic data protection and regulatory team here to assist you if you need help along the way. And I'm now going to pass you back to Tom for a final bit of housekeeping.
So thank you, Zoe and Charlotte, and thank you all for attending and listening to us. If anyone did ask any questions on the chat, then we will answer those. And we look forward to seeing you at our next webinar. So look out for that. Thank you very much.